Well, thank you very much for that introduction. And thank you, Amy and Alan and George, for this opportunity to speak here at the beautiful West Virginia University College of Law. I plan to briefly introduce some of the milestones in the field of AI and law, and to discuss how developments in large language models and generative AI are affecting them. AI is a sub-area of computer science in which researchers build programs that behave intelligently, and AI and law researchers develop computational models of legal expertise, models that can intelligently solve problems in the legal domain or assist humans in solving them. Since the inception of AI and law more than 50 years ago, researchers have tried to assist legal professionals in the practice of law, to provide fair and transparent access to justice, and to improve lawyers' training, skills, and effectiveness. Generally, academic researchers in the field have focused on developing computerized tools to help legal decision makers make better decisions, not tools that make the legal decisions by themselves. Today, the field must deal with new concerns, for example, how to address biases in data, how to protect data privacy and confidentiality, and how to prevent gaming the systems. In this first part of my talk, I will briefly describe these 5 milestones in AI and law research and development. Starting with legal expert systems. According to a pioneer in the field, Richard Susskind, expert systems are computer applications that contain representations of legal knowledge and expertise, which they can apply in solving problems and offering advice. In the 1980s, Don Waterman's expert system provided advice on settling product liability lawsuits. Today, law school clinics use expert systems to guide client interviews. Law firms use them to guide potential clients to the firm's relevant experts, and companies use them to guide regulatory compliance. Expert systems employ heuristic rules, rules of thumb. As heuristics, the rules are not guaranteed to lead to a correct result, but they are frequently useful. The rules are represented in a declarative language specifying their conditions and their conclusion. Here are some heuristic rules from Don Waterman's expert system. They define strict liability and loss in product liability. The system used these rules in recommending whether to settle a legal dispute and for how much. I'm allergic to PCs. I'm a Mac person, and I have to get used to it. The system used these rules in recommending whether to settle a legal dispute and for how much, as I said, and Waterman worked for the Rand Corporation, one of whose clients faced a large number of asbestos-related torts cases. The system's rules were manually formulated based on insurance claims adjusters' rules for calculating damages, and based on formalized statements of the California legal doctrine for product liability. Take a look at Rule 4, for example. This is the strict liability definition on the right. It says that if the product injures the plaintiff, or kills the decedent, or damages the plaintiff's product, then assert strict liability applies. How did the system know whether the system injured the product, injured the plaintiff, or killed the decedent, or damaged its property? Well, there were other rules, the rules over on the left-hand side. Expert systems only knew what the user told it and what the rules in its system allowed it to infer. That's all. And another significant limitation, as I mentioned, is the rules had to be created manually, which is an expensive process since they usually involved attorneys. A second milestone concerns computationally modeling legal rules. Law is a domain of rules, and computers are great at applying logical rules. So one might think this is an easy lift. It's not as easy as it sounds, however, and the field has learned some valuable lessons. We all know that legal rules employ semantically ambiguous or vague terms. We're taught that in law school. But they are also subject to syntactic or logical ambiguity. The problem is that natural language does not specify the scopes of the logical connectors, such as and, or if, or, and unless. In math, we can specify the scopes with parentheses. We don't do that in natural language or in statutes. In the 1970s, Professor Lehman Allen developed normalization, a manual way to tease out all the versions of a provision's logical structure. This is important because a normalized version of a statute can be run on a computer. Consider this seemingly straightforward one-sentence Louisiana criminal statute on the upper right. No person shall engage in or institute a local telephone call of an anonymous nature and therein use obscene, profane, vulgar, lewd, lascivious, or indecent language, suggestions or proposals of an obscene nature, and threats of any kind whatsoever. This simple statute raises a question. To violate it, must the anonymous call include obscene language and threats? Or is it enough if the call includes either? It makes a difference from a legal viewpoint. Criminal charges must be pled with particularity. In A, you see a normalized version of that one-sentence Louisiana criminal law provision. But note, there are two normalized versions. And if a knowledge engineer wants to implement this Louisiana statute in a computer, which version does she apply? The authority is the legislature. But as Lehman Allen pointed out, the legislature often is completely unaware of the logical ambiguity. And incidentally, it doesn't serve any purpose in terms of bringing legislature together in some kind of a compromise. It's just a mistake, an oversight. This problem persists today when one tries to extract logical rules from existing statutory and regulatory texts, or when large language models reason with these legal rules. Now, the most famous example of a computational model of legal rules is Marek Sergo's and colleagues' implementation of the British Nationality Act as a logic program. The system ran approximately 150 rules dealing with the acquisition of British citizenship. The inputs to the BNA program were a proposition to prove such as that Peter is a British citizen on a particular date by a particular section. The program outputs an answer and an explanation based on the rules. The BNA program was successful as far as it went, but as Anne Gardner pointed out, legal practitioners reason about legal rules, not just with them. Legal rules employ open-textured terms. They're subject to unstated conditions, assumptions, express or implied exceptions, and to conflicting rules in a statutory code. As a result, legal practitioners and systems need to model interpretive arguments about the meaning and application of a rule. For a variety of reasons, logic programming, as in the BNA program, was not sufficient for modeling interpretive arguments. Instead, researchers computationally modeled legal rules as defeasible inference rules. The rule's conclusions are treated as only presumably true, and the models employed argument schemes for supporting or attacking their conclusions. That brings us to a third AI and law milestone, knowledge-based computational models of legal argument. For example, the 2017 VJAP program employed argument schemes to represent patterns of legal argumentation. The schemes are templates or blueprints for typical kinds of legal arguments. As shown in A, argument schemes include, for example, arguing deductively from legal rules, arguing by analogy to past cases, or from values underlying the legal rules. Other schemes address responding to arguments by distinguishing a precedent or citing a trumping counterexample, or asking critical questions that point out exceptions in which the rule may not apply. As seen in A, one inputs the current fact situation, the argument schemes guide a search for a supporting argument or counter-argument to add to a graph, and when there are no more arguments to add, the model evaluates the overall argument. Computational argument models like VJAPs are knowledge-based. They explicitly represented a lot of legal knowledge. Beside the argument schemes, VJAP represented legal knowledge specific to the law of trade secret misappropriation, as shown in B. This legal knowledge included logical rules, underlying values, 121 trade secret cases and factors, stereotypical patterns of fact that strengthened or weakened a side's claim. These top-down knowledge-based models of interpretive legal arguments could predict case outcomes and explain them with those arguments. But they also had a glaring weakness. One had to represent this domain knowledge and the argument models manually. For instance, one had to read the Uniform Trade Secrets Act and construct the rules. One had to read the cases to determine the factors that applied in each case. In 2019, however, some remarkable events occurred, bringing us to the fourth milestone. Machine learning models classify case texts. First, Elias Chalkidis applied machine learning to predict case outcomes directly from the texts of the facts description. Their neural networks were bottom-up models. They didn't need legal rules. They worked directly from textual descriptions of a case's facts. For example, his model predicted if the European Court of Human Rights found a violation of any provisions of the Convention on Human Rights and of which provisions. Chalkidis' team trained and developed the networks with nearly 8,500 cases and tested it on 3,000 cases. 8 PCs. They employed hierarchical attention networks to automatically highlight the most predictive words as in A. Here one sees highlighted words like conclusion, concussion, admitted to hospital, bruises, and damaged. And this highlighting made some sense. The cases here are about Article 3 of the Convention, which prohibits torture and inhuman or degrading treatment or punishment. But according to Carl Branting's experiments, merely highlighting predictive portions of case texts does not amount to a meaningful legal explanation. Branting concluded that useful decision support should help the user understand the connection between relevant portions of the case record and the issues and reasoning in the case. In the SCALE project, Branting and his team manually annotated domain name dispute cases in terms of the arbitrator's factual and legal findings, the legal issues, and the factors affecting those issues, as shown in B. For example, the issue of no rights or legitimate interests, NRLI, and its related factor of prior business use, both highlighted in green, come from one of ICANN's rules governing domain name disputes. The rule states the importance of a bona fide business use of the domain name prior to notice of the dispute. Branting's team trained machine learning models to label the finding sentences in all the cases and to predict outcomes of unseen cases based on the automatically labeled findings, issues, and factors. The predictions were reasonably accurate, and as a bonus, the labels represented substantive, conceptual legal features that could be used to explain the predictions. If words in a case decision were highlighted as predictive, a system could connect them to the relevant legal rules and concepts. Now, the SCALE program stopped short of actually explaining its predictions. It was an empirical question how well these techniques would apply to legal domains with more complex and varied scenarios, and case language written by different judges, not by arbitrators. But my student, Morgan Gray, who you've already heard about, answered that question in the affirmative. And that brings us to the fifth AI and law milestone, designing and evaluating LLM and generative AI applications in law. Since 2019, researchers have been investigating how to apply large language models and generative AI to all of the milestones that I have just discussed. Now, LLMs help to extract logical rules directly from the statutory texts, rules that can be applied in legal expert systems or in computational models of reasoning with or about legal rules. LLMs can identify issues and factors in case texts almost as well as humans can. The LLMs follow natural language instructions or prompts, like in A, based on the same guidelines that instruct human annotators. Researchers apply machine learning algorithms to the cases and factors, as illustrated in B, to predict case outcomes, explain those predictions, and critique them, citing the most similar counterexamples. They apply LLMs to a corpus of legal decisions to identify factors from scratch in C and to compare them to existing factor lists in a legal domain, sometimes even discovering a new candidate factor. Prompts like D, based on argument schemes like those in the VJAP program, guide hybrids of LLMs and symbolic knowledge-based models in generating case-based legal arguments. Researchers like Morgan and my student Li Zhang are inventing empirical methods and objective measures to evaluate the generated arguments. Nowadays, LLM agents identify if other LLM agents made up case facts, should have abstained from making an argument due to factual weaknesses, or failed to recognize when cases are overruled, in a recent paper by Li Zhang. At a time when some generative AI legal applications are hallucinating facts, citing non-existent cases or citing cases for false or imagined propositions, these techniques for verifying these applications' trustworthiness will be the next AI and law milestone. Okay, so now I'm going to shift to illustrate some effects that LLMs and generative AI have on these milestones. My article addresses all of these, but for the sake of timing, I'm going to focus on numbers 1, 2, and 5. Let's start with how LLMs can be used to generate expert systems rules. Amy Seifert and Catherine Norton mentioned their interest in AI enabling access to justice. The authors of this paper had created a program called JusticeBot, a kind of expert system that assists laypeople to deal with legal problems of renting apartments or adoption, as well as other areas. The goal in this paper is to assist legal experts to construct rules for the JusticeBot system based on regulations. An LLM, GPT-4, starts with the regulatory texts, like the one on the bottom left, and extracts the legal rules, which are represented in a simplified form in the pathways, an example of which you see in the lower right. Here is the prompt the authors employed to get GPT-4 to extract the logical structure from statutory provisions. Your task is to extract the logical structure of a piece of legislation. I will give you the text from a legislation, determine the logical structure of the legislation, and return it in a JSON format. The structure to use contains two types of nodes, question nodes and information nodes. Question nodes correspond to logical requirements, a question that needs to be answered. Information nodes correspond to a logical conclusion, a logical consequence of the answers to the question. There's more, but you get the idea. For someone who learned to program in the 1980s, it's hard to imagine that a computer can accept and follow such detailed instructions written in natural language. We shouldn't forget that. These authors are inventing systematic means for humans to evaluate the generated pathways. They're not just examining a few examples and opining about whether they seem right or not. They're trying to generate objective measures. For lack of time, I won't say much about the evaluation. It's in the paper. But in general, the automatically generated pathways compared well with the human ones, at least for the easy and normally difficult provisions. The authors cautioned, however, that the results may not replicate to very complex articles or articles that can only be read in conjunction with other articles. Well, of course, we know most of the legislative articles are like that. So clearly, they haven't solved the problem of using LLMs to generate expert systems rules, but it's a promising start. Here's an example of inducing expert systems rules automatically from legal decision texts. From cases represented as shown at the top, the system induces rules like those at the bottom. These civil law cases are represented in terms of their fact description, their litigation process, legal analysis, and judgment result. At the bottom, we see that each legal rule has conditions that trigger the rule, behavioral prescriptions that govern conduct, for example, permitting, prohibiting, or obligating actions, as well as other legal consequences. The authors scraped more than 9 million civil and criminal cases from China judgments online. That's the wonderful thing about working in the Chinese context. They've got data. They clustered them into case sets that reference the same statutory articles, and thus the cases in each set are somewhat analogous. Then the authors apply an LLM, DeepSeek R1, to extract and structure the content of the cases. They created a data set of about 5,000 sets of cases and set aside 216 case sets, or about 1,600 cases, as a gold standard test set, which had been annotated by legal experts. The remainder constituted a training set. Next, the authors employed 4 different methods to induce sets of candidate legal rules from the training set. Each candidate rule was tested. If it applied to more than half of the cases in the set and instantiated a permission, prohibition, or obligation, it was kept in the rule set. They employed 4 different techniques to induce the rule sets: direct induction, chain of thought, long chain of thought, and an iterative induction and verification method called Silver. And then, using the gold standard test set, they evaluated how well the 4 baseline approaches and models performed. Silver's multi-turn induction and verification approach did best. That's the green line, substantially increasing recall, leading to higher F1 scores. That's the harmonic mean of precision and recall, a measure of accuracy in this context. They also employed a fine-tuning method, LoRa, to improve the performance even more. That's the purple line. And I think it's important because it's the first example I have seen of a program inducing a set of legal rules directly from the texts of a large set of cases. And of course, LLMs are doing much of the work. Now we ask, can LLMs reason like an expert system? Given LLMs and generative AI, do we even need these expert systems and their rules? Well, let's see. If you were trained as an American law student, you might remember this sort of question from your first-year contracts course. It presents a complicated series of exchanges of purchase orders and messages between a potential buyer and seller. On July 1, buyer sent a telegram to seller, "Have customers for salt and need carload immediately. Will you supply carload at $2.40 per hundredweight?" Second, on July 12th, seller sent a telegram saying, "Accept your offer, carload of salt, immediate shipment, terms, cash on delivery." But then in 3, the buyer sent its standard form purchase order, whose terms do not match the seller's telegram. At 4, the putative buyer finds a better deal elsewhere and tries to repudiate its supposed acceptance. And the ultimate question is number 5. If seller sues buyer for breach of contract, what result? I think it's a prime example of a legal problem that would appear to require reasoning. Well, first, let's see how a classic knowledge-based expert system performed the reasoning and answered the question. This picture is an augmented transition network, an ATN, for offer and acceptance problems. and Gardner programmed it for her 1987 PhD dissertation at Stanford. An ATN has states, the circles, and arcs. It's a kind of legal expert system. Legal rules are associated with the arcs. These rules govern the transition from one state to the next. We start at state 0, no relevant legal relationship. If the input event satisfies the rules for an offer, we move to state 1, offer pending. If an event satisfies the rules for an acceptance, we move to state 2, contract exists, and so forth. The program recorded these events in a detailed analysis tree, or DAT. If the rules for moving to a new state raised a hard legal question, for example, presented 2 legally defensible ways to evaluate an event, the system inserts a branch for each in the DAT. Of course, back then, computers could not process natural language text. So Anne Gardner represented the facts of a problem as a set of logic propositions. Here is how she represented just one sentence proposing the sale of a carload of salt. And, of course, she had to represent all the sentences that we saw by hand. Natural language output was also a problem. This is the general analysis tree, that DAT I mentioned. It outlines 9 paths to a final state. 3 result in contracts, and 6 result in no contract. Notice the choice point at 1. In effect, it's asking, is the first telegram an offer, not just an inquiry, or not an offer? The choice point at 6 asks, in effect, assuming the second telegram is an offer, is the purchase order an acceptance and proposal to modify or a counteroffer? This shows the ATN's detailed analysis of event 3. Hard to see, but notice the branching midway along the left side where the program asks, which rule? The common law rule, which was called Williston, a contracts treatise, that required an acceptance mirror the terms of the offer, or UCC section 2-207, the provision that relaxed the common law's mirror rule. So there are 2 inconsistent rules depending on which law applies, and a branch gets inserted. So, can an LLM perform this analysis? I asked Anthropic's Claude 4.5 to analyze the same contracts problem. Here are 4 items of correspondence, I said in my prompt. Briefly analyze each of the items of correspondence in terms of its effect under contract law. Indicate what the result will be in seller's action against buyer for breach of contract. And then I appended the 4 events exactly as you saw them in the first slide. Here's Claude's analysis of the events. Claude says the July 1 buyer's telegram is an invitation to treat, not an offer. No contract formed. As to the July 12th seller's telegram, Claude says, despite seller's characterization as an acceptance, this is actually an offer by seller. Seller is now proposing definite terms. This creates the power of acceptance in buyer. Regarding the July 13 buyer's purchase order, Claude says, although it purports to accept seller's July 12 offer, it adds a materially different term, 30-day payment instead of cash on delivery. It points out that under the mirror image rule at common law, this would be a counteroffer and rejection of seller's offer. Claude continues under UCC 2-207, governing the sale of goods. This operates as an acceptance with additional terms. As to the July 13 buyer's rejection telegram, buyer cannot reject an offer it has already accepted, Claude tells us. Result, in seller's breach action, seller will likely prevail. And of course, Claude constructed this response in a matter of seconds. Now, the fact that Claude 4.5's answer covers both the common law analysis and that applying UCC section 2-207 is good, because 6 months ago, Claude 3.5 did not mention UCC section 2-207 until I asked about it. However, I gave Claude's answer to my daughter, an in-house contracts attorney. She read it, and she immediately asked, was there a prior course of dealing between these parties? In their course of dealing, they may have treated such an inquiry as an offer. Claude 4.5 didn't mention this. Does it know about prior course of dealing? Well, let's ask. When I asked Claude 4.5, under what factual circumstances could the July 1 telegram from buyer be an offer, Claude lists some circumstances that would support characterizing it as an offer. Notice I fashioned the prompt not to give away the answer. Claude says if the language of the commitment were more definite, if the buyer specified all the essential terms, and then Claude gets down to what I was looking for. Number 3, prior course of dealing. If buyer and seller had an established business relationship where similar telegrams were routinely treated as binding offers, this pattern would support interpreting July 1 as an offer. So Claude knows about prior course of dealing, but I needed to prompt it, and that means the user needs to know an awful lot about contract law in order to get all of the information that's relevant. Nevertheless, we see that the LLM performs some sophisticated legal reasoning about an offer and acceptance problem. Its reasoning appears to be comparable to that of an expert system dedicated to the topic of offer and acceptance, such as Gardner's top-down computational model. With LLMs like Claude 4.5, do we even need expert systems anymore? Well, here we prompted 6 LLMs with the same initial prompt as for Claude 4.5. 4 of the LLMs conclude that the seller wins. 2 conclude that the seller loses. 2 versions of Claude 4.5 disagree as to who wins, whether buyer's July 1 was an offer and the legal status of the buyer's July 13 purchase order. Even LLMs whose results agree demonstrate variations in legally classifying the events and their effects. The responses are reasonable. A law professor would likely approve such responses from students, assuming the student explained why some are preferable to others. Given the probabilistic behavior of LLMs, this diversity in responses is not surprising, but it is consistent with the proposition. But is it consistent with the proposition that LLMs can replace legal expert systems? While the LLMs sometimes identify alternative analyses, common law versus UCC, the user needs to pull out other alternatives with follow-up prompts. That is, the user must know enough about the problem to ask the right additional questions. The LLM's multiple responses beg some questions. In what sense, if any, does the LLM have a computational model of offer and acceptance? We know it doesn't have the kind of top-down legal knowledge that an expert system has. Apparently, the knowledge lies implicitly in the language model's enormous neural network trained on that huge corpus of texts, including legal texts. The prompts provide a framework for the LLM's predictive statistics of what tokens likely come next resulting in generating sentences that appear to embody legal knowledge and result in reasonable legal analyses. Can Claude 4.5 deal with syntactic ambiguity? I submitted the Louisiana statute that we saw earlier, and then I asked, suppose Harry and Beth are both in the capital city of state A, and Harry makes an anonymous telephone call to Beth in which Harry threatens Beth. Has Harry violated the statute? Claude responds, the key interpretive issue is how to read the conjunction and that appears before threats of any kind whatsoever. The natural reading of this statute, it says, is that the threats must be connected to the preceding language about obscene, indecent content. And Claude outputs a proposed structure for the provision. Claude continues, the final phrase, threats of any kind whatsoever, appears as part of a list that begins with obscenity-related content. It cites the principle of iustem generis, of the same kind, to argue that the threat should share the character of being obscene, profane, vulgar, or indecent. If Harry's threat was purely a threat, it says, without obscene or indecent content, he likely hasn't violated this statute. Then it goes on to say, that said, a court could interpret threats of any kind whatsoever literally to mean any threat, but that reading creates tension with the statute's structure and apparent purpose. In sum, Claude recognizes there's an interpretive problem with the and that appears before threats of any kind whatsoever, so it's certainly on the right track. It resolves the syntactic ambiguity, but maybe it expressed a bit too much certainty about the conclusion. I would suggest that instead of considering only one logical interpretation of the statute at the top, Claude should also consider a plausible alternative structure of the provision at the bottom. But I give it high marks. How about the problem of open textured terms? Can Claude help us with that? Here is H.L.A. Hart's famous example. Vehicles are not permitted in this park. I asked Claude, for purposes of the rule, are 10-speed bicycles vehicles? It answered, this is a much closer case than the baby carriages that I had asked it for before, a genuine penumbral case where the answer isn't obvious. It then proceeded to give arguments that bicycles are vehicles. These included arguments from ordinary meaning, from literal interpretation, and from the rule's purposes. If the rule aims to protect pedestrian safety, for example, noting bicycles can injure pedestrians, then bicycles arguably threaten these interests. Claude is channeling Lon Fuller here. And then, without further prompting, it makes arguments that bicycles are not vehicles, including an argument from context and purpose. If the rule's primary concern is motorized traffic, noise, pollution, danger, non-motorized bicycles don't implicate these concerns as strongly. Well, you can see this opens up lots of fundamental questions, research questions, for AI and law, and perhaps for you too, to try out on your own. One of those research questions is, how well can LLMs perform statutory reasoning? A recent study asked whether and how well GPT-3 can perform statutory reasoning. The authors tested whether GPT-3 could identify whether a specific subsection of an unfamiliar statute is applicable to a given set of facts, and if so, what that implies. This figure shows prompts used to post test cases to GPT-3 regarding statutes in a statutory reasoning assessment database called SARA, which covers 9 sections of the U.S. tax code. The questions provide a premise and a hypothesis mentioning a tax statute and ask whether the statute entails the hypothesis. The top boxes in orange contain the statute provision used in the prompts. They employed few-shot prompts and zero-shot prompts. The few-shot prompts had examples, you see them in blue, of what the user is looking for as an answer, and in the zero-shot, there are no example cases. And the test cases are at the bottom in green. The text highlighted in yellow is generated by GPT-3. They assessed how well GPT-3 performed on the SARA tax questions. In the last column, you can see the accuracy of the various GPT-3 prompts. The accuracy ranges from a low of 38% to a high of 71%. It's often doing better than a majority baseline or the BERT-based then state-of-the-art when the paper was written. It's not great, but these results indicate it's doing something right, and it looks like simple reasoning with statutes. Simple statutes, by the way. Finally, let's examine some recent effects on designing legal applications of LLMs and generative AI. Increasingly, we're seeing hybrid combinations of LLMs and top-down knowledge-based models. Here's an LLM-based neurosymbolic framework for legal judgment prediction of private lending cases under Chinese civil law. The text of a sample case is shown at the top left. It's a simple dispute over an unpaid loan where the creditor sued the debtor. In step 1, an LLM, GPT-4, extracts 15 elements from the fact description's text, such as the date of the loan's amount, and the date of maturity. In step 2, based on the text of the fact description, a deep neural network predicts the claims that are raised in the case and their outcomes. That step is a data-driven bottom-up approach, like Branting's scale program that we saw before, where it identifies relevant fact elements in the case text and predicts an outcome. Meanwhile, in step 3, a rule-based logic model determines the claims that apply in the case and determines their outcomes. This is a top-down knowledge-based approach, similar to Waterman's expert system. And then the data-driven neural network and the knowledge-based rule-based model come together in step 4, which I will try to explain. It turns out the neural network's outputs on the training set are not always correct. There may be a training loss. The logic model's rule-based predictions are also not always correct. They call that a discrepancy loss. And in step 4, the logic model's results update the neural network's results by updating the weights, and the neural network results lead to changes in the rules to minimize the discrepancy loss. And thus, logical reasoning, the symbolic component, is integrated with the neural network in hybrid systems involving an LLM. Now, these authors noted that their approach is mainly for simple civil cases like private lending, where the facts are clear and the rights and obligations are well defined, making AI technologies particularly adept at accurately identifying the case details. I just wanted to point out that my students, Morgan Gray and Li Zhang, are working on different hybrid approaches, integrating LLMs and knowledge-based methods in the work that I mentioned earlier that focus on more complex cases and common law legal argument. So to conclude, LLMs and generative AI have affected all of the AI and law milestones, and we see that LLM generative AI hybrids are integrating knowledge-based models for specific legal tasks. And with that, I'll conclude.
All right, we'll open it up for questions.
So I wonder what you think the next thing we ought to be teaching students is. Like for folks in law school, I mean, and for full disclosure, I took his text analytics class at Pitt, and it was great. If you were to design the next class for law students, what do you think of all this we should give to students who don't come in with a tech background?
Yeah, that's a good question. Before I heard Professor Fairfield this morning, I would have said teaching law students to be good editors of the outputs of the AI system, which I think is still a good answer, although the considerations he made me realize just how sophisticated and difficult that task is. And there are ways in which I hadn't even imagined one needs to be an editor. By editor, I mean bring a critical sensibility to it and analyze the answer and the extent to which one can rely on the answer. I think that's still the fundamental problem. My students are, of course, developing LLM agents to do some of that analysis. And they're having some success, at least identifying places where the LLM should simply say, I don't know. I can't make an argument with this. That would be helpful. They're also focusing on getting the LLM to understand more of the underlying meaning in a case. So to be able to realize that even when to realize that a proposition may have been overturned in a subsequent case, and in the experiments, the LLM clearly knows about the subsequent case, but often doesn't make that connection. So that kind of critiquing is what we should focus on.
Well, I have one for you, Professor Ashley. So as we progress and AI is more and more integrated into integral tasks, how do we balance the weights on these models with things that have different moral judgments? And where I'm coming from, the example I've thought of for probably a year now is when we get better with self-driving cars that are fully autonomous, and there are situations where as humans, we react with instinct, not thought, because we can't process it fast enough when we have to make a critical decision. But for example, if a car is going to get in an accident, the AA might have time to think of a choice that might protect the user, might protect the pedestrian in front of it. And how do we balance those weights? Does the AI, the model, protect, if it has to hit one person, does it hit the old person versus the young person? Does it protect the driver versus the car beside it? How do we weigh those moral choices into models?
Short answer is, I don't know. I've done some work modeling ethical reasoning using knowledge-based techniques. My students have had some success with that, but to be truthful, I'm looking forward to doing the same sort of thing that I illustrated in the talk, starting with a knowledge-based approach that worked pretty well, and then seeing what the LLM does with it in this ethical domain, which happens to have been implementing a set of ethics rules that a professional society of engineers provided. And the ethics rules are very abstract. And so we have to make these judgments whether they apply in this circumstance or not. And it's difficult. And in that domain, they don't even have the detailed rules that we do in legal ethics. I don't know how to deal with it. And after Professor Fairfield pointed out that any guardrails can be circumvented, I just, it's an area certainly for future research, but practically I have no suggestion.
Thank you. Do we have any other questions? We still have some time here.
Alan has.
Thank you again for coming, Professor Ashley. I have a question. So I feel like one of the three basic answers that, we give in law school to a question is yes, no, or it depends. It seems like the LLMs right now are really good at giving a yes or no answer. And kind of going off your example with the offer and acceptance, not so good as giving an it depends, or Professor Fairfield was talking about this morning, it's not good at saying I don't know something, without additional prompting at least. Do you foresee in the future that it gets to that point, or are these LLMs just going to be so constrained to wanting to give a direct answer?
Very good question, and one that I'm working on with Li Zhang. One initial question is, what would you tinker with in the LLM to change so that it did identify the branches better and bring them to the attention of the user? Is it a matter of training it over and over again to do that, or is it a matter of getting under the hood and tweaking things, or is it a matter of subjecting the system to a set of learning rules that would guide its outputs less in the direction of certainty and more in the direction of choice? That's an empirical question, and all I can say at this point is we're working.
Anyone else?
Thank you so much. It was a great presentation. I always say, and I said this morning, I'm so proud of us for having these classes since 2020, but of course our colleague pointed out that you've been teaching these classes since 1989. So there's a lot more interest in the field now probably than ever. What is it that folks who are just now coming to AI and law as a discipline, what is it they get wrong? What is the thing you would most want people to understand based on having been a leader in this field for decades?
Yes, I've been in the field since 1989, or even before that, the mid-'80s, and I have to confess that for the lion's share of that period, nobody gave a damn about what I did. And then all of a sudden, when I'm at retirement age, I can't retire anymore because it's gotten so darn interesting. After hearing Professor Fairfield's talk, I'm wondering if the A in AI is really alien intelligence. It's clearly intelligent. We've seen examples of intelligence, but it's very different from the way we function. And so I think that what I was so impressed with is he has an intuitive understanding of the implications of this statistical learning method that is unleashed on us. And so understanding how it works, but also getting that intuitive sense of what the implications are, that's the thing that I'm missing, and probably newcomers are missing as well.
We have time for maybe one or two more questions.
There's one back there.
So this has kind of been in the back of my head all day. but it seems to me that maybe a core function is the obsession with the efficiency and trying to make it, I guess, as cost effective as possible. Do you see that as an issue for why it's driven to give a yes or no answer instead of a maybe, because a maybe is not as satisfying as a yes or no? And with that in mind, do you think that there's a future where maybe we create a system that, okay, it's not, don't you don't need to be as effective as possible and save us money. You just need to give an accurate answer. Do you think that could is that possible? Because obviously AI is immensely expensive. And then is it probable? Is it something that could potentially solve this issue? My knowledge on it's very limited, but it's been racking my head this entire time.
Yeah, I think we have to remember where are these systems coming from? They're coming from the commercial sector. And the commercial sector is desperate to raise the huge funds that they need for the power to run the systems. And I think that coming up with a certain answer or the appearance of certainty about an answer sells better than the alternative. Nobody wants to think about alternatives, right? And it's tragic in a way. I personally regard it as tragic in that I'm teaching students to do research, and there are so few opportunities in academia anymore for AI and law researchers. They end up going into the commercial sector, and once they get in the commercial sector, even my students who go and do internships, they sign non-disclosure agreements, and when they come back, they can't tell me about what they've done. My sense is that the commercial providers are really poisoning us, our society, and it's really tragic. There was an article in the Wall Street Journal of the Times, I think it was yesterday, that yes, the programmers have become so much more efficient and they have produced these reams of code, but there still is the need to determine whether it's reliable or not. And so far, it's humans who are doing that, although they're trying to get yet more LLMs to do that task as well. But doesn't that count as inefficiency? That has to be taken into the balance. So it's a very sad situation that we're in.
Well, that was really great. Oh, here we have one more. No, yeah, that's good.
Thank you so much. I've been thinking that since we can't control what is being given to us in terms of AI, unless we are actually the owner or the programmer, why not use our intelligence to combine it with the AI? So we know they want to give us a yes/no answer. So why not? So I'm a labor law expert. I teach labor law. I've been teaching it for 20 years. So for me, I always like to test AI with labor law so I could see how accurate it is. So what I've learned is how to manipulate AI by doing that. So when I want to see multiple answers like this, I just say, here's my question. What are arguments on both sides? And what is closer to the line? Can you provide a vignette that's closer to the line? So I start prompting it in different ways. And I test it with labor law again because I know it so well, so I know exactly where it is. And of course, I tell my students, you don't know labor law like I know it, so you put this in, you're going to get wrong answers. You might get some right answers. So please don't do that unless you know that you're going to get some wrong answers. But then I tell them, I say I know this because I've tested it. But then I can use it on something else and see. Then I go back and do the research. And I say, well, how close did it get? So I've been tinkering with this. I'm just wondering what you think about that. kind of combining the alien intelligence, which I love that you said that, with human intelligence?
It's a very much understudied area. I think it's so important to look at the use case. What do we want what kind of a problem are we asking the AI to solve? And then figure out the interaction between the employees and the AI relative to that. And part of that is identifying the shortcomings of the AI, where they're going to have to be careful, or else they'll come up with some wrong answers, or they'll need to know what to do with those wrong answers, that kind of thing. And it's an interesting problem in that who's studying that? Not my students, really. They're not going to get a PhD in computer science for that kind of research. Maybe they should, but I don't think in general computer science departments are open to that. It's a kind of combination of applied sociology and computer science. Somebody ought to.
Or psychology also.
Or psychology,
Yeah.
yeah. It's a social science kind of a problem. Very good point.
Thank you, thank you.
Well, join me in giving Professor Ashley a big round of applause.